10 reasons why you should have a living trust. Many real estate gurus advise homeowners and buy and hold investors to put their properties into an LLC, and some advise one LLC per property. But if you live in California, did you know that the Franchise Tax Board will charge you $800 for every business entity you have, even if you don't use it? So why not put all your properties into a single living trust, which has a yearly cost of exactly $0 and has at least 9 other benefits to you and your family, including keeping your heirs out of probate.
Welcome to Rock Real Estate with Simone, where we make real estate informative and fun. And now, here's your associate broker, real estate attorney, and mortgage loan originator, Simone.
Welcome back to Simone's Rock Real Estate channel, where we provide valuable information on personal finance and estate planning, as well as real estate. Today, we're going to dive into the topic of living trusts and explore whether they could be the right choice for you. About 20% of Americans have living trusts, and the number is growing. In this video, we'll discuss what a living trust is and 10 good reasons why you should have one. So let's get started. First off, let's talk about who should have a living trust. I firmly believe, from the bottom of my heart, that every adult who owns at least one property should have a living trust. Why? Well, I've personally had to go through probate as an attorney and as a beneficiary, and it is a full-blown court proceeding that can take well over a year, in California maybe 2 years, with a number of court hearings and a huge hassle for the executor, and where tens of thousands of dollars from the estate will be given to the probate attorney. And trust me, an attorney is necessary. So let's get more specific about who needs a living trust the most. If you live in California and check off one or more of the following, then you absolutely should have a living trust. 1. You own real estate anywhere in the USA worth over $184,500 as of 2023. 2. You have heirs, children, grandchildren, or other family members or close friends. 3. Bonus points if you are single, and that's because you have no spouse to automatically inherit should you pass away. 4. More bonus points if you own real estate in multiple states. That's because your heirs would need to open a separate probate case in each state where each property is located. Now, let's understand what a trust is and what it does. People ask me all the time, what is a trust? Well, now I could give you a legal definition, boring, but I prefer to compare it to something most people already know about, a corporation. Trust documents are like corporate documents in that they are legal entities created by contract law that have certain elements to them. The grantor or settlor of the trust is like the founder of the company. The trustee is like the CEO or president of a corporation, the person who runs the show. The beneficiaries of the trust are like the stockholders or shareholders of the corporation, and as the name implies, are the ones who benefit or stand to benefit from the operation of the trust. All right? Pretty cool. Pretty easy, huh? So what exactly is a living trust? A living trust is a type of trust that is designed primarily as a powerful estate planning tool. This revocable trust is a legal arrangement through which you can distribute your personal and real property after you die. Unlike a will, which only becomes effective upon your death, a living trust is established during your lifetime, so it not only determines how your assets are distributed after you pass away, but also has a number of benefits for you while you are alive and kicking. That's the living part. Now, as the grantor, you establish the trust and transfer your property and assets into it. You choose the beneficiaries who will eventually receive the trust assets in whatever manner you see fit. And you also appoint a trustee to manage the trust, and one or more successor trustees who become the new CEO after you pass away. You, the grantor, determine the powers of the trustee. Some people just say, well, whatever the trustee decides to do, and that would be called a discretionary trust, while others spell out what happens to every single piece of property in the estate in great detail. It can get as complicated as you like, and an estate plan can also appoint guardians for minor children and provide for kids and adults with special needs. Heck, you can even establish a pet trust for that special four-legged someone in your life. Can I hear a woof? Now, the really interesting thing about the living trust is that you and your spouse or partner, if you choose to do it jointly, are the grantor, the trustee, and, while you're alive, the beneficiary. Speaking of jointly, The most common living trust is with a couple, typically married, and the two partners are the co-grantors and co-trustees. The trust is still living until the second spouse partner passes away. Once the last grantor passes away, the trust instantly becomes irrevocable, and the first successor trustee now becomes the trustee and is legally obligated to follow the instructions that you made in the estate planning documents. As I mentioned a moment ago, some people give this new trustee very specific and detailed instructions, while others give the acting trustee full discretion to use their best judgment. And if you have minor children when you pass away, a guardian that you nominated in your estate plan now becomes the new parent of the children, thus avoiding any potential family disagreements. Now, you may have heard that there are two main types of trusts, revocable trusts and irrevocable trusts. While only two letters are different in their spelling, they are completely different legal tools and entities. The living trust that we're talking about today is a revocable trust, which is much more common than the irrevocable variety. Although the legal term is revocable trust, it really should be called an amendable trust, as people rarely revoke them but often make changes or amendments to them over time. The IRS calls it a grantor trust because you, the grantor, have full control over it. You can easily transfer assets to and from the revocable trust, amend it, or even terminate it or revoke the trust. On the other hand, the whole point of having an irrevocable trust is that you have no control over it. And in fact, the assets that you place into an irrevocable trust are no longer legally owned by you. They are controlled by the trustee, a third party, somebody other than yourself. Now, in my opinion, irrevocable trust should rarely be used, as irrevocable means forever, and once they're created, you can't change your mind. They are commonly used for elderly wealthy people to get out of the federal estate tax, which doesn't apply to a couple with less than an estate worth $12.92 million in 2023. Only 0.04% of estates paid that tax since it was raised by the Tax Cuts and Jobs Act of 2018. Now, by the way, in 2026, the estate tax might kick in at a lower amount if the bill is not renewed. Now, the other main group who use revocable trusts are those interested in true asset protection. In other words, people who are expecting to be sued or perhaps contemplating a nasty divorce, or they're just paranoid. The property in the irrevocable trust is safe from creditors because, as I stated above, you legally don't own it anymore. Now note, revocable living trust distributions are typically not taxable as they are considered gifts and not income. But irrevocable trust distributions could well be subject to taxation depending on who receives them and how much they receive. Now, if you're truly concerned about asset protection, there are other less drastic ways to shield your property from potential creditors, such as land trusts. You would have each property in its own land trust, and like an irrevocable trust, the trustee of the land trust is a third party. However, that's where the similarities end, as 1, the land trust is revocable and amendable, and 2, the trustee is obligated to follow your directions and instructions. Now, if you're interested, I'll be talking about land trusts in another vlog right here at Rock Real Estate, so stay tuned for that one. Now that we understand what a living trust is, let's explore the many benefits that make it an attractive option for many individuals and families. All right, here we go. Benefit number 1, avoiding probate. One of the biggest advantages of a living trust is it allows your heirs to avoid the time-consuming and expensive probate process. When you title your assets in the name of the trust, they are no longer considered part of your probate estate. Now, this means that your beneficiaries can receive these assets much more quickly and easily after you pass away without the need for court intervention. Don't forget, a will should be called a will not, because a will alone will not keep your heirs from having to suffer through the probate process. So, what is the magic that allows this to happen? Well, if your property is owned, let's say, by the Smart Family Living Trust while you're alive, who owns it after you die? That's right, if you're smart, got the answer. It's the Smart Family Living Trust. The trust owned the property before you passed and after you passed away. So there really wasn't a transfer of title, as the only change was really in the trustee. Avoiding probate is an even bigger deal if you own property in multiple states. Did you know that if you passed away without proper estate planning, a separate court case would need to be opened in every state where you own real estate? And that's more attorneys. If you are a buy and hold investor with properties around the country, that means your heirs would have to file multiple cases and hire attorneys in multiple states. That's no bueno. All right, benefit number 2. Maintaining control and flexibility. With a living trust, you can retain maximum control and flexibility over your assets. You can make changes to the trust throughout your life to accommodate new plans or beneficiaries. This document allows you to ensure that your intentions with estate planning are plainly evident, making it challenging for disgruntled family members to contest the trust. We put in a no contest clause to avoid that. And remember, if your heirs have to open a probate case, you don't decide what happens to your property, a judge does. Benefit 3. Customized asset distribution. A living trust allows you to determine precisely how your assets are distributed. Truly, what the trust can do is only limited by your imagination, as long as it's legal. Whether you want your beneficiary or beneficiaries to receive a certain amount of income per month, or have specific conditions for asset distributions, such as graduating from college, a living trust ensures that your intentions are met. You can decide what percentages or what property each beneficiary receives and how things are distributed if one or more of them pass away before you do. All the possibilities are considered in a good estate plan. Benefit 4. Privacy and confidentiality. Now, privacy is a crucial aspect of estate planning for many individuals. While a will becomes part of the public record when the probate case opens, a living trust remains a private document. The trust's details, including the identity of the beneficiaries and the distribution of assets, are not accessible to the public. This privacy allows you to maintain confidentiality within your family and ensures that your plans are not open to scrutiny or potential challenges. You instruct your successor trustee what to do, and he handles it after you pass as a private matter. All right, benefit 5. Capital gains tax benefits. Heirs don't pay taxes on living trust distributions in California. I have counseled many people who wanted to put one or more family members on title while they were alive. I always have to remind them that the state and federal laws are favorable to property transfers at death and penalize those who make inter vivos transfers, even to their kids. Always keep in mind this general rule: inheriting is good. Beneficiaries save big on federal and state capital gains tax if they inherit the property. Now, so what if you want to transfer title to your home now during your lifetime to your beneficiary? Well, if you put them on title now, you transfer your current tax basis to them, which is the price you purchased the property for way back when. So they would have to pay tax on the difference between what you paid for the property some time ago and what it's worth whenever they sell it sometime in the future, which could be a huge amount if you own the property for a long time. They could pay a massive tax even if they sold it immediately after you gave it to them. On the other hand, if you place your property in your living trust and have them receive the property when you pass away, then your heirs will get a new tax basis to the current market value at the time of your passing. If they sold it right away, they'd pay no capital gains tax at all. Eventually, when they did sell it, the capital gains tax would be much lower because the starting point will be the fair market value when they inherited it, not the price that you purchased it for years ago. Also, you won't have to worry if they get into an accident, file for bankruptcy, or have an IRS audit, since they won't yet be on title to your property. All right, benefit 6. Property tax benefits. Your heirs would also save big on property tax reassessment, especially for California properties. If you transfer your property while you're alive, in many cases the property will be reassessed to its current fair market value. Now, thanks to California's unique property tax scheme due to Proposition 13, your property tax bill could increase drastically if you own the house for a long time. Remember, Proposition 13 substantially limited the amount that your property taxes can rise each year. So if you've owned the property a long time, you are paying much less property tax than you would in any other state. Post Proposition 19, children and grandchildren can avoid this reassessment, but only if they live and continue to live in the property as their primary residence. Otherwise, the person you are making an inter vivos gift to would be saddled with a much larger property tax bill than you are paying. Benefit 7. Cost savings to California investors. As I mentioned at the very beginning, many California real estate investors have LLCs or some form of corporation. Many national real estate investing gurus advise buy and hold investors to form a separate LLC for every property. That does afford some asset protection, but did you know that even if your California business entity has $0 in transactions for the year, that the tax bill for that entity is still $800? Well, okay, maybe you knew that. So you just go ahead and open a Nevada or Wyoming LLC to avoid that. Well, guess what? If the California Franchise Tax Board determines that you are a California resident, money's coming into your California account, then they will bill you $800 per entity no matter where your LLCs or your properties are located. If you have 5 LLCs, that's $4,000 a state tax bill for starters. Yikes! Compare that to a living trust or land trust, which costs you nothing. So putting your properties in your living trust can save you real money every year if you haven't got around to forming an LLC or two. Benefit 8. Well, what if you already have an LLC? Well, you can assign the LLC to your living trust, which won't save you the $800, but it would give you some added asset protection and keep the business moving when you pass away. And you will. Companies find themselves in critical financial distress or out of business altogether due to estate taxes or other related hardships that result from the death of an owner or key partner. In your living trust, you appoint a successor trustee and instruct them to continue the business operations after you pass away. Not only that, but a living trust package is an ideal way to keep assets under your control if you become mentally or physically unable to manage, as we include a springing durable power of attorney and a springing advanced healthcare directive as well. You might want to consult with an experienced business attorney and or business CPA to determine if having your trust own your business entity is the right setup for you, as it does add a level of complexity to your business. Benefit number 9. Financial protection for your heirs. Living trusts also have a special benefit to the heirs of a Californian's estate. Did you know that if you end up having medical major bills at the end of your life, as many people do who have long treatments for cancer and other terminal diseases, that your medical bills can be recovered by California from your estate when you pass away? In other words, if you leave your loved ones a $900,000 house free and clear and you have $1 billion in medical bills, your heirs would be forced to sell the house and your loved ones would get nothing. Well, that's a big deal. Under state law, and this is true in most states, Medicare and Medicaid, Medi-Cal, or whatever it's called in your state, bills must be paid from the estate. But for Medi-Cal members who died on or after January 1st, 2017, recovery by the state is limited only to estate assets subject to probate that were owned by the deceased beneficiary at the time of death. So if you have a living trust, your heirs are not subject to probate and they are not subject to paying for your unpaid medical expenses. Now, that's a big deal, I think. In addition, a living trust can protect beneficiaries from disabilities, from losing their supplemental security income or SSI benefits. Under current federal rules, SSI recipients can be disqualified from receiving benefits if they come into an inheritance. Even if they disclaim the inheritance, they may still be hit with a significant penalty, depending on the value of their share. A carefully crafted living trust can avoid this issue with the inclusion of a special needs trust, which allows the individual with special needs to receive the inheritance in a separate account earmarked for non-Medicaid use. They will then continue to collect SSI benefits in support of their disability. A living trust can also address future plans for disabled adults living in the home, should the grantor pass away, typically with a provision that provides a lifetime interest or life estate in the estate asset for those individuals. So there you have it. 10 great reasons to get yourself a living trust. Now, of course, determining whether a living trust is right for you is a personal decision based on your unique circumstances and goals. But the benefits that I just described make it a very appealing option for most successful people. And if you go to the nice neighborhoods, you'll find that the title in the houses there are almost all in living trusts. Now, if you're considering setting up a living trust, we highly recommend consulting with an experienced estate planning attorney, especially one knowledgeable in California laws and real estate. They can guide you through the process, ensure all your legal documents are in order, and help you create a comprehensive estate plan. I happen to know a great estate planning attorney. That would be me! For further info, check out SimoneLegal.com or contact me any way you like. Our comprehensive living trust package features a 20-page living trust and also includes a certificate of trust, pour over will, durable power of attorney, HIPAA waiver, advanced healthcare directive, a final arrangement section, and the real estate title deeds that you will need to fund the trust. This whole enchilada A to Z estate plan offers numerous benefits during one's lifetime, such as enabling the people you choose to make medical and financial decisions and giving them access to your medical records if you ever became legally incapacitated. And of course, it ensures a smooth transition after passing, preventing family disputes, and providing guidance on funeral arrangements and asset distribution. My two passions are real estate and estate planning, and I would be pleased to help you with either or both. You can set up a free estate planning or real estate consultation at stuartsimone.com. Well, thank you for joining us today. If you found this video helpful, don't forget to like and subscribe to our channel for more fun and informative content. As always, please consult a professional advisor before making any significant legal or financial decisions. Until next time, take care and plan wisely.